All right, good morning, everyone. This is CV 2023-093001 in the matter of Jeane Dumbrell versus Vimala Ramnachandran. This is the time set for an oral argument on the defendant's motion for summary judgment. Can I have counsels for the parties please announce for the record, starting with counsel for defendants?
Good morning, Your Honor. Dustin Christner on behalf of Dr. Ramachandran.
Thank you. And Dr. Shah?
Good morning, Your Honor. For the plaintiff, Zahir Shah.
Great. Thank you. All right, I have reviewed the motion for summary judgment, the response, the reply, the associated statement of facts, as well as the motion to strike sham affidavit and the response thereto. I've allocated 20 minutes to each side for this matter. I'll hear first from defendant's counsel, as it is your motion, and then I'll hear from plaintiff and defendant's counsel. If you would like to reserve any time for rebuttal, it'll be your responsibility to properly reserve that time, and I'll try to give you some updates when you're getting down to about 5 minutes during your main argument. With all of that stated, any questions or any other preliminary matters to discuss before we get started? Mr. Christner?
No, Your Honor.
Dr. Shah?
No, Your Honor.
All right. Then, Mr. Christner, you may proceed.
Yes, Your Honor. I would like to reserve 5 minutes for rebuttal. I'll try to keep an eye on my time here. Your Honor, this is the time to hear this motion for summary judgment and the motion to strike Dr. Miller's affidavit that was only produced and disclosed after the close of discovery, after 11 hours of deposition with Dr. Miller, and after defendant filed a motion for summary judgment, which is dispositive of all of plaintiff's medical malpractice claims. Dr. Miller, in this case, gave the discovery deadline in this case was March 16th of 2026. Dr. Miller's last deposition was March 25th of 2025. Plaintiff's last disclosure statement regarding anything, including expert opinions, was June 25th of 2025. We filed this motion for summary judgment on March 26th of 2026. Plaintiff responded on May 4th, 2026 with the new affidavit from Dr. Miller. The new affidavit from Dr. Miller contains new opinions that were never disclosed in a timely fashion. They weren't disclosed before the close of discovery. They weren't disclosed after 11 hours of deposition testimony from Dr. Miller. They weren't disclosed when Dr. Miller had the opportunity to review his deposition transcript and make corrections. They weren't disclosed after the defense expert, Dr. Hanker, was deposed and his transcript was available. These opinions from Dr. Miller weren't disclosed after Dr. Nolan, who was a fact witness in this case, had her deposition taken and the transcript was provided to Dr. Miller. He never updated any of his opinions until after the close of discovery and after we filed a motion for summary judgment. His affidavit Mr.
Christner, you're getting a lot into what seems to me might be a disclosure sanction rather than the arguments that were raised in the motion to strike sham affidavit, which are more akin to the affidavit's a sham affidavit because it's containing new or supplemental opinions that were not provided in the deposition, and one of the limited exceptions to such depositions doesn't exist. For example, that the person who was deposed was confused, or that they learned new information after the deposition. And so I guess maybe you should clarify for me here. Are you now raising disclosure sanctions, or did I miss something in your motion to strike?
Well, it's disclosure sanctions was part of the motion, and also that it's a sham affidavit attempting to get around motion for summary judgment. Rule 26.1 F2 and Rule 37 C1 says that new opinions and the basis may not be disclosed after the scheduling order deadline absent leave of court, and any undisclosed opinions may not be used as evidence at trial, at a hearing, or with respect to a motion. We're here on with respect to a motion for summary judgment, so those arguments and rules certainly apply to Dr. Miller's affidavit. In addition, his affidavit contradicts his prior testimony and comes in with new opinions that could have been disclosed timely, but weren't. His affidavit says that the opinions stated in the affidavit are not new opinions, but his affidavit references the deposition of Dr. Hanker and Dr. Nolan, both of which were any opinions from Dr. Miller regarding those two depositions would have occurred after Dr. Miller's 11 hours of deposition and were never just timely disclosed. So there are new opinions and new basis for opinions, and the intent is to avoid summary judgment. Plaintiff, in his response to the motion to strike, in response to my motion to strike, concedes that Dr. Miller's affidavit is only a cumulative support alongside deposition citations, and that striking the